This is the record for the estate of Nadia Romanov, docket S-8455, in the Union County probate part. Segment 1. The initial filing. The stated corpus is $1,378,831. The public guardian filed its account, asking the court to settle it and discharge the guardian, quote, in a summary manner on order to show cause. The accompanying documents show the application of that math. On September 30, 2025, the summary detailed over $30,000 in total commissions due to the public guardian, calculated directly from that full $1.3 million corpus as the base. The state asked the court to settle on the papers, moving toward final discharge. Final summary approval relies on the accuracy of the accounting and its supporting procedure. Segment 2. The accounting contained a discrepancy. Included was a $64,455 Ameritrade line. Those funds had already moved to a Charles Schwab account. The money was counted twice. The administratrix objected, and the proponent conceded this inclusion was improper. The court acknowledged the issue in a subsequent order. Paragraph 2 of this November 3, 2025 order gives the parties 30 days to discuss correcting deficiencies in the accounting as noted by defendant on the record. The official court record confirms that this $64,000 double count existed in the base. The official court files show the financial document governing the estate was mathematically flawed. Segment 3. The sequence of events. The accounting containing that $64,000 double count had already been formally approved. On April 4, 2025, the court signed the order and judgment. The judgment declared that the first and final account be, quote, in all things settled and allowed as recorded. That approval would be reversed 7 months later. The judge vacated the April decision, stating it was signed in error. A footnote records that counsel, quote, failed to notify the court of the error. A full 7 months passed between the initial error and the eventual correction. A mathematical error of $64,000 went uncorrected, leaving the judgment in place for over half a year. Segment 4. The final question. How does a contested accounting, containing a conceded phantom line, achieve final grant while the objector is never heard on the merits? We will examine the circumstances, the rules, the record against itself, and what the rules describe instead. The record answers that question in its own words. This investigation is based on the documents permanently inked into the court's own files.
This is Act 2. We are mapping a precise window of time from October 18, 2024 to March 2, 2026. These are the circumstances, the procedural history a pro se litigant navigated, defined by a death, a withdrawal, and a continuous discovery schedule. We will look strictly at the file-stamped record. These documents track a sequence of events that doesn't require outside interpretation to understand. Segment 1. The timeline begins on October 18, 2024, with the death of Nadia Romanov. Under New Jersey Statute 3B12-64, a guardian's authority terminates immediately upon the death of the ward. However, the same statute preserves the guardian's obligation to account for the estate. 19 months after her death, the guardian's own proposed judgment still directed that several awards be paid out of the estate. Filing fees, audit fees, commissions, and counsel fees were to be pulled, quote, from the deceased ward's funds in the public guardian's possession. The estate's money remained physically held by the opposing party, while the estate was required to litigate just to see the ledger. Segment 2. On May 8, 2025, the administratrix, Yana Belevre, answered the accounting complaint. A discovery schedule followed on May 20th. On June 13th, the Office of the Public Guardian served interrogatories and document demands on her lawyer, which was the proper procedure at the time. On July 11, 2025, the court issued an order relieving her lawyer. It granted her 30 days to either retain new counsel or proceed pro se. On that same day, a second order set a new deadline for all written discovery, August 1st. This gave the defendant 21 days to file responses, while the necessary case papers remained at the relieved lawyer's office. The court granted 30 days to find a lawyer, while simultaneously setting a discovery deadline that expired 9 days before that window closed. Segment 3. Despite the conflicting orders, discovery actively ran in both directions during the summer of 2025.
The administratrix served her own demands on the Guardian. The OPG's later certification concedes they served their responses on her on August 1st and August 4th. Evidence of this summer effort appears a year later in the fee pro forma submitted by the Guardian's own counsel. On July 29th and 30th, counsel billed for preparing responses to interrogations and discoveries. The next line shows billing for reviewing and bait stamping discovery documents. The move-in's financial audit shows they were actively processing documents from the administratrix, confirming she was participating in the case during the very window she was supposedly non-compliant. Segment 4. The case moved through a series of resets in late 2025, a vacatur in November, the defendant appearing pro se, and a proofs hearing in December. On January 16, 2026, a new case management order officially captioned her as a pro se defendant. It reset the written discovery deadline to March 2nd. This order included a warning: failure to comply could result in a motion to strike her pleadings. Her responses arrived on March 3rd, exactly 1 day past that deadline. On March 5th, the court ordered the Guardian's counsel to hand the decedent's own 1099 tax documents to her estate and to resend their discovery. The opposing counsel held the threat as striking pleadings over a pro se litigant for missing a deadline, while they were simultaneously ordered to hand over the tax documents she needed to respond. That is the terrain. Now the rules that govern it.
This is Act 3, an objective analysis of the rules of procedure applied in the matter of the estate of Nadia Romanov, docket S8455. It is an examination of logic and law, relying strictly on the court's own file-stamped record. It accuses no one of a crime. New Jersey's legal rules are constructed as a deliberate, cumulative staircase. They are engineered to act as safeguards, ensuring that a litigant's right to present evidence and be heard is protected at every level. This slide outlines Segment 1. Under Rule 483(1), probate actions begin in a summary manner, meaning they start with a complaint and an order to show cause. But that summary form is a starting posture, not a final verdict. Rule 467(5) has two sides. If no one objects, or if the papers clearly show there is no genuine issue of material fact, the court may simply rule on the pleadings. However, an objected to accounting containing a conceded phantom line is the textbook definition of a genuine issue. Here is the text of Rule 467-5. It states explicitly that if any party objects and there may be a genuine issue as to a material fact, the court shall hear the evidence. Shall. The baseline architecture of the system defaults to examining the evidence rather than dismissing it for the sake of procedural convenience. This brings us to Segment 2, the discovery track. When a party fails to provide discovery, Rule 423-5 prescribes a strict, deliberate two-step process. Step 1 allows a pleading to be dismissed or suppressed, but strictly without prejudice. This step builds in immediate protections. The client or pro se party must be served a prescribed notice explaining the consequences. Crucially, it provides a clear cure path. Provide the missing discovery, pay a modest restoration fee, and move to vacate the order. Step 2 is the with prejudice motion, but the law places a rigid temporal gate in front of this action. As shown in the rule text here, Step 2 can only be initiated after the expiration of 60 days from the date of the order. It requires a second notice and a mandatory appearance. Even then, a default judgment under Rule 443(1) is downstream of all of this. It permits entry of default only after an answer has been officially strucken with prejudice. A without prejudice order is a legally constructed invitation to cure a defect. It acts as a temporal break to prevent sudden, fatal defaults. Segment 3 introduces a complication. What happens when answers exist, but the opponent calls them incomplete? The Appellate Division answered this in Adedoyan v. Ark of Morris County. They ruled incomplete answers cannot automatically be treated as a total failure to answer. The party entitled to the answers cannot dictate the future course of the proceeding simply by asserting that the submissions were not fully responsive. Here is the published opinion. The court dictates that the objecting party should promptly supply the judge with the interrogatories and answers. The judge, not the opponent, must analyze the material, identify the specific questions needing more, and order compliance.
This is the April 13, 2026 court order handling this exact case. The highlighted section quotes the Adedoyan command directly, acknowledging that the judge must be supplied the answers so the court can properly focus on the dispute. The law forces judicial scrutiny over discovery disputes, specifically to strip litigants of the power to weaponize incomplete answers into automatic dismissals. This brings us to Segment 4, the highest threshold in New Jersey procedure, the terminal sanction doctrine. The Supreme Court established dismissal with prejudice is the ultimate sanction, reserved only for violations striking the foundation of the cause of action, or for deliberate contumacious refusals. Terminal sanctions are imposed only sparingly, ordered only when no lesser sanction will suffice to erase prejudice to the non-delinquent party. Furthermore, Jansen establishes a vital protection rule. It is neither necessary nor proper to visit the sins of the attorney upon a blameless client. And SWH funding provides a final safety net, establishing that applications to vacate defaults must be viewed with great liberality. Every reasonable ground for indulgence is tolerated to ensure a just result. For a litigant to be silenced by the court, they must sequentially fall through the baseline right to a hearing, bypass the temporal cure period, fail judicial scrutiny of discovery, and meet the Supreme Court's stringent requirements for an ultimate sanction. These are the rules. Now put the record beside the rules.
This interlude in the matter of the estate of Nadia Romanov examines two filings, an order from April 2025 and a proposed judgment from May 2026. Segment 1. These two documents were filed 13 months apart. Despite the time between them, they share an identical framing of the case. The April 4, 2025 order granting the accounting recites that the guardian sought a settlement, quote, in a summary manner on order to show cause. It continues with a standard recital, the court having reviewed the papers submitted and for other good cause shown. 13 months later, the May 21, 2026 proposed final judgment carries that same sentence, word for word. This recital survived a vacatur, months of discovery, and a struck answer. The text remained unchanged even as the litigation moved through these different stages. Segment 2. To understand the significance of that label, we have to look at how the court rules define the beginning and end of an action.
Rule 483-1 makes probate actions begin in a summary manner. Rule 467-5 controls what happens next. If no party objects, the court can try the action on the papers. But if a party objects and there is a genuine issue as to a material fact, the rule is clear. The court shall hear the evidence as to those matters which may be genuinely in issue. In this framework, summary is a starting posture. It is not a destiny. Segment 3. Between the original order and the new proposed judgment, the case moved away from that starting posture. The record shows the filing of exceptions and an answer, followed by a case management order with specific discovery deadlines. Discovery included 25 interrogations reaching into family finances and identifying who entered the Ward's house. By early 2026, the docket included a reservice order and a motion to strike. Consider the hypothetical: a case that demands interrogatories by the dozen on Monday and calls itself summary on Friday is, in the vocabulary of the rules, one of two things: converted or mislabeled. Segment 4. The summary label carries a specific result: judgment on the papers, without an evidentiary hearing, witnesses, or cross-examination. The innocent explanation is the recital merely describes history. Rule 4.83-1 requires the actions start this way, and proposed orders copy recitals by drafting habit. A recital of a posture the docket has outgrown is a request to be judged by the standard the case outgrew. Whether this text is boilerplate or a deliberate request is a question. Hearings are where questions like it are answered. The label never changed. The case did.
This is an interlude chapter, focusing on the filed orders between July 2025 and April 2026. The quotes and text you are about to see are drawn verbatim from the file-stamped filings and orders in docket S8455.
A court docket acts as a purely objective map of a case's procedural history. It records the routes taken to resolve a dispute, without inherently proving that the final destination was pre-planned. Segment 1. Our map begins with a closed road. On April 4, 2025, a judgment took the accounting on the papers. 7 months later, on November 3rd, it was vacated. Under core procedural rules, a vacated summary judgment originally entered on the papers does not automatically convert the case into a trial. Here is the raw evidence: the November 3rd order vacating that previous judgment. The caption confirms the filing date, and the text specifically orders the vacatur. As a result, instead of moving forward to a plenary hearing with witnesses, the case went looking for another procedural road to reach a final judgment on the papers. Every step in this record has an innocent twin. After a judgment is undone by an error, the ordinary innocent course is simply to finish discovery, a standard path that naturally ends in a new judgment. Segment 2. On July 11, 2025, the adversary's lawyer was officially relieved. The order recites the standard a court must weigh: the prejudice to the client, the proximity of the trial date, and the possibility to obtain other representation. But looking at the court's actual statement of reasons, the application paragraph ultimately turns on unpaid fees and a breakdown of communication. This created a specific timeline conflict. A 30-day extension gave the defendant until approximately August 10th to find new counsel. Yet the deadline for written discovery was August 1st. The required answers came due before the search for a lawyer was scheduled to end. The innocent twin for this segment: motions for withdrawal due to non-payment are entirely routine, and this one was unopposed. Segment 3. Prior to the withdrawal of counsel, case management conferences had been conducted over the phone. This is the August 21, 2025 case management order. As the first order issued after the defendant lost counsel, it mandates the unrepresented co-administrators to appear in person. The practical disparity here is clear. An unrepresented party must now stand alone in a physical room against professional counsel who navigate these proceedings for a living. The innocent twin: courts generally prefer live appearances. Mandating an in-person order is the ordinary way a conference is held, not an intentional penalty. Now we move to the final piece, Segment 4. The January 16, 2026 status conference order officially designates her on the record as a pro se defendant. It dictates new discovery deadlines, allowing written discovery to be served, with answers required by March 2nd. This is the exact language from the order itself regarding non-compliance. Paragraph 4 explicitly states that if the demands are not met, a notice of motion to strike pleadings may be filed. This specific motion to strike was pre-written directly into the schedule, pre-cleared by the court, before the actual answers were even due. Consider the innocent twin. Strict deadlines and early strike warnings are entirely ordinary case management tools, and each road taken here features one. The immediate consequence of that timeline was realized on April 13th, when the defendant's answer was officially struck. Exactly 38 days after the strike, a new motion was filed. This motion explicitly asked for final judgment on the papers. To be clear on the objective record, this is merely a request for a judgment, not its entry. No final judgment has been entered on this record. But over the course of 9 months, 4 isolated, structurally innocent procedural steps consecutively navigated the docket back to its original goal, a disposition on the papers, without a contested hearing. They are simply different doors, all leading to the exact same room. This is Act 4 of 5 of Granted Without Hearing Her, the S8455 accounting endgame, the record against itself. This is analysis of logic and law. It accuses no one of a crime. Every fact in this investigation is drawn strictly from the file-stamped documents of docket S8455. We are relying entirely on the written record to establish the timeline and the rules of engagement. We will deconstruct 3 specific pieces of that record: the strike motion, the strike order, and the final judgment package. Through these documents, we can observe the precise mechanics of a court stripping a pro se party of their defense, relying on a record that directly contradicts its own sworn premises. Segment 1. The motion concedes there were answers.
It asks to strike for failure to provide complete responses. Look at the caption on the move-in's own notice of motion. The filing does not claim an absence of discovery. The attack is specifically on the completeness of the responses provided. This certification from the move-in reveals a paradox. In paragraph 13, they admit under oath they received the responses on March 3rd, 1 day past the deadline. To support the motion, they physically attached all 25 of the parties' answers as Exhibit 5. This physical attachment triggers a specific legal standard under New Jersey case law, known as Adedoyan. When discovery answers are placed in front of the judge, the court cannot simply take the moving party's word that those answers are deficient. Because the move-in supplied the very answers they were criticizing, the burden immediately shifted to the judge to conduct a line-by-line analysis to determine what was actually missing. Segment 2. The order quotes Adedoyan, then declines to apply it because the pro se party did not oppose. This is the court's written statement of reasons. The judge explicitly acknowledges the mandatory review required by Adedoyan, and then writes, "did not oppose." Thus, this court does not need to make the additional considerations. This logic breaks the safeguard. The entire purpose of the Adedoyan review is to ensure that a strike does not rest solely on the move-in's say-so, preventing the court from simply rubber stamping an unopposed motion. The answers were already in the motion packet. By making the judge's mandatory review contingent on a pro se party writing a formal opposition brief, the court hands absolute control right back to the move-in. Further down in the order, the text carries over grammar from an entirely different file. It refers to the administratrix Yana Belevre plaintiffs and strikes a defendant's answer. This is a probate accounting. There are no defendants. The court functionally struck the defense in this matter while short-circuiting the exact case law it cited to justify the action. We now move to Segment 3, analyzing the move-in's own counter-record. Returning to the move-in's sworn certification, paragraph 13 exposes a contradiction regarding their own obligations. They swear to the court that they served their discovery responses to the pro se party back in August 2025. Yet a subsequent court order in March 2026 had to explicitly direct the guardian's counsel to hand the decedent's own 1099 tax documents over to the estate and resend that exact written discovery. The discovery demands themselves consisted of 25 interrogatories, layered with subparts, probing deeply into family finances and visitor logs to the ward's house. This is plenary-scale, highly intrusive discovery, deployed in an estate matter where the proposed judgment legally dictates it should proceed in a summary manner. This brings us to Segment 4, where we examine the endgame math. This is the April 13th order. Under Rule 423-5, the initial strike of the answer was granted without prejudice. That rule is strictly designed as an invitation to cure. It mandates a 60-day window following a without prejudice order before any final, irreversible action can be taken against the delinquent party. But the required secondary with prejudice motion never happened. Instead, the final judgment motion was dated on day 29 and filed on day 38. The required 60-day cure window was bypassed completely. At the end of this fast-track timeline sits the financial extraction. The proposed judgment awards commissions of $31,244 and counsel fees of $37,521, every dollar payable from the deceased ward's funds. And on the proof of service for that final judgment motion, an inexplicable anomaly appears in the caption: Attorney for Plaintiff, LCR Management, Inc., an entity completely foreign to the stocket. The strict mathematical fail-safes of civil procedure were ignored, allowing a flawed record to accelerate the massive transfer of an estate's wealth. The rules describe a different ending. When the procedural rules built to protect an individual are dismantled by the very court responsible for enforcing them, the documentary record is all that remains to prove what actually happened. This is an interlude chapter, The Money. We are examining the April 4, 2025 Judgment Awards, the Guardian's own filed accounting, and the fee arc that followed. All of this takes place within the matter of the estate of Nadia Romanov, docket S8455. Every quote in this chapter is taken verbatim from the file-stamped filings and orders. Segment 1. The size of the pot and the claims against it. The Guardian's own revised account October 2, 2025,
closes the trust account at exactly $195,471.63. Against that pot, the April 4, 2025 judgment awarded $33,147 in commissions, $27,711 for the public guardian's professional fees and costs, an audit fee of $5,819, counsel fees of $4,430. That is roughly $71,000 awarded against a finite trust. Looking directly at the order's face, the court marked most of these sums with a specific phrase, still due and owing. The baseline reality of this case starts here. A closed estate with a fixed balance faces tens of thousands of dollars in explicitly unpaid financial demands, all authorized by a single court document. Segment 2, the fee arc. The counsel fee did not stay at $4,430. In an application filed May 21, 2026, the demand asks for $37,521.64. That is roughly 8.5 times the vacated award, billed to the estate for the exact same legal engagement, including discovery. In New Jersey, Rule 4.42.9 permits legal fees to be drawn from a fund in court on a sworn affidavit of services. That affidavit is then measured against the strict guidelines of Rule of Professional Conduct 1.5 to determine if the hours billed are legally justified. Under these rules, the burden of proving that those legal fees are reasonable sits entirely on the lawyer asking for the money. Multiplying a legal fee by 8.5 triggers a strict burden of proof. The applicant must produce clear evidence that every hour billed was necessary. Segment 3, the working test. Probate courts rely on an enforceable standard with teeth. In the Bales estate, the appellate division surcharged an executor for imprudence, yet still allowed his commissions and counsel fees. They did so because his services, quoting the court, were necessary to the proper administration of the estate. Necessary to administration is what estate money may legally buy. Consider the hypothetical. An estate is billed for the defense of its own correction. The lawyers litigate against the very exception that ultimately proves the original accounting was wrong. In that scenario, the estate has funded both sides of its own case. A court has to sort the billed hours to determine which side of the Bales line each hour falls on. Sorting those hours is exactly what an evidentiary fee hearing is for. It forces the court to separate the time spent managing the trust from the time spent defending an error. Segment 4, timing. The April 4 judgment awarded the fees and marked most of them still due and owing. 7 months later, on November 3, 2025, that exact judgment was vacated. The law of restitution has long required that money paid under a judgment that falls must be restored. If any award was already disbursed under the vacated judgment, the obligation to return those funds reaches whoever holds them. If the money was never disbursed, the legal authority to move those funds fell at the exact moment the judgment did. Either branch of this reality presents a serious legal question regarding the custody of the estate's money. Courts answer questions of this magnitude with formal hearings. Yet, looking at the vacated order, we can see exactly how the initial awards were granted. The court approved them on the papers, quote, in a summary manner on order to show cause. Every figure in this chapter is from a filed document.
We have reached an interlude. The accounting endgame within docket S8455 presents procedural and logical conflicts, examined here as 7 hypotheticals. This analysis follows a strict conditional framework. These documents establish a factual pattern only if a hearing tests and proves the underlying events. Every documented contradiction has what we might call an innocent twin, a benign administrative explanation, such as an inherited file, a calendar error, or a slow office. The court system uses evidentiary hearings to tell these twins apart. Because the court struck the administratrix's answer, the hearing designed to resolve these specific hypotheticals never occurred. Segment 1 addresses a contradiction in discovery. Hypothetical 1 involves a sworn certification telling the court the administratrix failed to provide complete responses to interrogations or any responses to a notice to produce documents. The immediate friction here is that the same motion making the claim of failure actually attaches the 25 answered interrogatories among its own exhibits.
Hypothetical 2 examines the service timeline. The Guardian's counsel claimed discovery went out in June 2025, yet in March 2026, a court order still had to direct counsel to send another copy of those same documents. The innocent twin for this segment is that complete is a subjective qualifier, or that a simple mail failure occurred. Logically, if the initial service was complete, the March order was unnecessary. If the order was necessary, the original service story remains incomplete. Segment 2 looks at procedural mechanics. Hypothetical 3 contrasts the official summary designation of the case against a docket filled with deposition schedules and case management deadlines. Hypothetical 4 involves the mechanics of the strike. Under the rules, a strike without prejudice is only the first step of a mandatory two-step process intended to allow for a cure. The record shows the strike, followed by a final judgment motion moving at day 38 of the mandated 60-day rule window, with no second step in the file. The innocent twin for this timeline would be a calendar error or an office that simply processes paperwork at a different pace. When the final sanction arrives before the rule's own mandated calendar allows for it, the record indicates that the rule was cited rather than followed. Segment 3 focuses on the financial accounting. Hypothetical 5 involves an estate paying its fiduciary's lawyer to defend an accounting that the fiduciary later corrected. Hypothetical 6 deals with commissions computed on an account line that the proponent conceded was counted twice, money that had already moved to another account before the count. This results in a percentage being taken from funds that were not physically there for the fiduciary to administer. A commission calculated on non-existent funds cannot be factually reconciled within the accounting records. Segment 4 addresses a logistical trap. Hypothetical 7. While the Guardian held every record of the estate, a March 2026 order directed its counsel to hand the decedent's tax forms to the family. The family issued subpoenas for the underlying records to fulfill that duty, but the Guardian successfully moved to quash those subpoenas. Ordering a family to fulfill a tax duty while simultaneously withholding the records required to complete that duty creates a logistical obstacle. While motions to quash exist for valid reasons, the specific timing of these actions prevented an orderly transition of the estate records. The innocent twin of every hypothetical here is an inherited file, a scheduling mistake, or a slow office. The law's primary instrument for telling these twins apart is a hearing, with witnesses testifying under oath. This analysis makes no accusations. It presents the pages and the logical conditions they create, conditions that were meant to be resolved by the hearing that did not happen. Every hypothetical here has an innocent twin. The hearing is where twins are told apart. This is Act 5 of 5, What the Rules Describe. We conclude this study and procedure entirely within the objective framework of the rules themselves. The analysis ahead relies strictly on logic and law and accuses no one of a crime. We start with the first procedural test. Segment 1, the discovery path. Under the Adoyan standard, discovery answers go directly to the judge. The court reads them against the context of the case, names the specific interrogatories that fall short, and explicitly orders compliance within a certain time frame. A strike can only follow a defiance of that precise order. On the physical record of this docket, no court ever found the March 3rd responses deficient, not question by question, nor as a whole. Because that foundational judicial finding never occurred, any subsequent procedural punishments were built on a discovery path that failed to meet the mandatory legal standard. This brings us to the second procedural test, Segment 2, the sanction path. Rule 423-5 outlines a strict escalating sequence. A pro se litigant must receive plain language notice, a mandatory 60 days to cure any issue, and faces a with prejudice strike only after a second motion, a mandatory court appearance, and a judicial finding that nothing was cured. These steps must be measured against the Jansen and Abtrax doctrines, which hold that the ultimate sanction of a dismissal is not appropriate for a litigant whose attorney withdrew in the middle of discovery. New Jersey law deliberately constructs this multi-step buffer so that an unrepresented person cannot lose their case purely on procedural friction without exhaustive notice, which leads to the third and final test, Segment 3, the merits path. Under Rule 467-5, when an accounting faces exceptions that present a genuine issue of material fact, the instruction to the court is absolute. It shall hear the evidence. This document shows what the court knew. This is the November 3rd vacatur order. The record itself acknowledges the original grant was signed in error and formally records that there were deficiencies in the accounting as noted by defendant on the record. When a dispute is recognized on the record like this, Rule 1.7-4 dictates what happens next. The exceptions are engaged, the commissions are tested against the actual work performed, and the final discharge must be earned on a plenary record. The legal framework strictly forbids skipping straight to a summary judgment when the court's own physical documents formally confirm an unresolved material dispute. Segment 4 details what actually occurred. The sequence began with a without prejudice strike that explicitly quoted the legal safeguard, only to set it aside. The necessary with prejudice step never happened. Instead, a final judgment motion was filed while the mandatory cure window was still wide open. We can verify this timeline anomaly directly on the notice of motion. The stamp reads May 21st.
This was day 38 of the 60-day cure window. Bypassing these procedural steps had immediate financial consequences for the estate. Counsel fees grew eightfold from the time of the vacated order, payable entirely from the deceased Wart's funds that were still in the guardian's possession. The proposed order and judgment reveals exactly how these funds were distributed. After authorizing $37,521 for the attorney, the document casually defines the surviving estate's inheritance in 6 words. The balance, if any, shall be paid over. This video accuses no one of a crime. It simply reads the filed record beside the rules that govern it and lets each describe the other. The law was on the page. The orders looked away.